Hello dear students, my name is Malakmatova Marim, and today we're going to continue our lectures on jurisprudence. So we have two last lectures, and the topic of lecture number 1 is going to be labor law. So let's start. So from the theory of the state and law, it is known that all branches of law differ among themselves according to the three reasoning: the subject, the method of legal regulation, and the source. So the subject of labor law are labor relations and relations directly related to them. Under the employment relationship, in accordance with the labor code of the Kyrgyz Republic, is understood the relationship based on the agreement between the employee and the employer on personal performance by the employee for a payment of the labor function, subordination of the employee to the rules of internal labor regulations, ensuring the employer of the working conditions stipulated by the labor legislation. So what it means, guys, that before we already discussed different types of laws: administrative law, criminal law, and etc. So today we're going to talk about labor law. So what it means is that there is, again, normative facts or documents, yes, documentation of any state which has everything related to this particular law inside of it. So we're talking about labor law today. It means that there is a labor code. If we're talking about Kyrgyz Republic, yes, so there is a labor code. So this is a document inside of which we have everything which is related to labor relations. What are labor relations? It is when there are relationships between employer and employee, yes, meaning that there is a worker and there is a person who's giving a work to this person. So everything has to have rules, yes. Again, everything in this world is trying to be in balance, being harmonized, yes, because when there is a chaos, nothing good can come from it. So there are rules which employees and employers have to follow to have a good relations. Meaning that employee, yes, if you're talking about the person who's gonna worker, he has his rights, but also he has requirements for this job. He has obligations, meaning his duties, what he has to do in this working place. And if we talk about employer, the person who's giving the job to this person is that employer has to provide good working conditions so the person can make all of his duties possible. Also, he has to take care about the safety, yes, about the safety of the working place, safety for the employee, and he has to pay a corresponding wage or salary to the employee for the job that he is doing, yes. So this is everything, like the basics of any labor relations, guys. Labor code. So the labor code is the main source of labor law. It is labor code. Thus, labor law is an independent branch of law representing a set of legal rules governing the employment relationship with the workers and employers. The system of labor law is divided into general and special parts. In general part, rules apply to all public relations regulated by labor code. The special part includes institutes that regulate the issues of concluding, changing, and terminating the employment contract, working time, rest time, payment and standardization of labor, guarantee and compensation payments, labor discipline, labor protection. A special part of the labor law regulates the issues of international legal regulations of labor relations. So it means that labor code, again, yes. So the labor code, this is the main document or main normative act of labor relations in Kyrgyz Republic. We're talking about Kyrgyz Republic now, yes. We take it as an example when we talk about laws. So we have labor code, which consists of two parts. There is a general part and special part. Again, even the name of the terms can explain you everything. So general meaning it takes labor relations in general, yes, like what are labor relations? What do they mean? What do they consist of? But when we go to the special part, it makes concrete, yes? It makes concrete labor relations, meaning that it tells you about contract, about working contract, how it has to be concluded, what should be included in this working contract, beginning from the working time. Yes, if we're talking about full-time job, like from 8 to 5 p.m., maybe this is part-time job, maybe this is a freelance job, yes, which is really popular nowadays because of the corona crisis. Also, the rest time should be written there, that after 5 p.m., worker has no obligations to stay at work and work till late, yes, because job is already done. Also, rest time is about days off. Is it Saturday or Sunday? Are those different days? About holidays, like once a year, twice a year, how many days? Is this, are these holidays paid by the worker or the employee itself? What should worker do if he's sick? Does he has to go to the hospital and provide some papers from the doctor that he was actually sick? Everything about rights and obligations and duties of worker and employee, yes, are written in a special part of the labor code. So why it is done, guys? We've already have discussed it, yes, partially when we talked about another types of laws. Why do we need laws? So law is a written document. Those are written rules which have to be followed by any citizen in the population. The matter, so there is a thing. Let's imagine that there is any person, yes? He doesn't know anything about laws, he never read about it, he never heard about it, and he broke a law. For example, just something simple. He broke something which belongs to the city, yes, which is municipal, like he ruined some property, for example. He drew graffiti on it, for example. He didn't know that it was unlawful, but he did it. And the matter of fact that he didn't know doesn't free him from the consequences of the thing that he did. That's why it is really important for any person, guys. Especially in the 21st century, it is really important to know as much as you can. You're gonna become doctors, yes, one day, hopefully. But the thing that you're gonna become a doctor doesn't mean that you have to know only everything related to your specialization. The more you know, the better your life will be, because knowledge is power, guys. So you don't need to know only about the medicine, but it will be really good for you if you will know basics about economics, yes? So you will know everything about taxes, you will know about business and etc. Maybe if you want to, for example, open your private clinic, you need to know about jurisprudence, because whenever you'll be working, yes, you will be under the labor code or any other documentation which states for the labor law of the state where you're gonna work. So you need to know your rights. So why do we need the law? Law protects you. Yes, law does protect every citizen, every person who's living in this particular state. So inside of the law, we have not only obligations or requirements or duties like what person should do, but also it consists of the things that person has rights for. Like the main rights of the Constitution for any person is right for life, is right for freedom, is right for free speech and etc. So again, knowledge is power, guys. So if you know your rights, then it will be easier for you to live, guys. So labor law is there to protect you, because if something happens whenever you're working, yes, maybe you get injured during your work, labor law will protect you. If you didn't do any mistake and it was a mistake of the employer, then he will have to compensate you the harm, yes, that was done while you were working, while you were at your working place, guys. So employment contract. Employment contract is an agreement between the employer and the employee, in accordance with which the employer undertakes to provide the employee with work on the stipulated labor function, to provide the working conditions stipulated by the labor legislation and other legal acts containing labor law norms, the collective agreement, local normative acts, and this agreement in a timely manner. In practical activities, labor and civil relations should be distinguished. In general, the difference between an employment contract and civil law contracts related to the application of labor is not only of theoretical but also of significant practical importance. When concluding a labor agreement, a citizen is subject to labor legislation, and he must be provided with the appropriate social guarantees. Working under civil law contracts, such guarantees are not used. The parties to the employment contract are the employee and the employer. As an employee, only individual can act. As a general rule, the age at which a contract of employment is possible is 16 years. The employer can act as a physical, in the case of work in the personal household of the employer or work for an individual entrepreneur, and a legal entity that has the right to take and dismiss employees. So what it means, guys, so the basic document of any legal labor relations between employer and employee is employment contract. So whenever any person is going to find a job, he found a job and he wants to work there, he wants to do this work, number one thing that should be done is employment contract should be filled out by the employee and the employer. And it is really important to discuss everything, yes, to discuss everything which is written in the employment contract, to read it thoroughly, yes, to be really accurate, because sometimes there are things that you maybe do not agree with, but after signing it, you will have to do them. So, employment contract, it is concluded between employer and the employee, yes, and employment contract has to have all the things which are related to the job, all the things which are related to salary, to wage, to working times, to rest times. And also, since we're talking about labor law, we're not talking about civil law now, yes? Labor law gives you social guarantees. What it means is that, for example, you're working on a governmental job, yes? You're working for a governmental hospital. It means that your salary is fixed. It doesn't depend, we're talking about Kyrgyz Republic right now, yes, as an example. Your salary is fixed. It doesn't depend if in this month, for example, you've observed 10 patients and in last month you observed 50 patients. It doesn't matter because it is fixed, yes. So social guarantees is that you're getting your salary on time, yes, we're talking about governmental hospital. You're gonna get your salary on time. You have your own days off, yes. You have months when you can go for holidays, and holidays are totally paid by the government, yes. They are giving you money like a salary for this month when you're off, when you're not working. Also, since we're talking about lawful relationships, yes, meaning that there is a contract and you're under law, it means that you're paying taxes. You are paying taxes from your salary, and the employer is also paying taxes from the income. Your taxes are going for your insurance, yes? Medical insurance, for example. Whenever you're gonna get sick, you can go to the hospital and you can be sure that you're gonna get medical help for free. Also, part of your taxes is going for the government, yes? So they can, it is going to the budget. So the government can spend this money for governmental spends, expenditure. Also, the part of this taxes is going for your future. Whenever you're gonna retire, yes, you're gonna get retirement payment after you stop working. So labor law and employment contract gives you those guarantees. And the thing is that it is written in the beginning of the slide that it has a timely manner, meaning whenever you're filling out the employment contract, usually it is done for the period of 1 year. For example, yes, 1 year. After 1 year, you and the employer are gonna decide if you want to continue working there, if you're gonna prolong the employment contract or you want to stop it. It depends on different situations, yes. For example, you don't want to work there anymore, then you're just gonna say that you don't want to work, you don't want to continue those labor relations and you're just gonna go, yes. Also, there can be situation when employer doesn't want you to work there anymore. Maybe you're not fulfilling your duties, maybe you're not working properly, maybe you're always late and etc. Yes, no matter what, and he's gonna explain you this and tell you that, well, we're sorry, but we don't want to work with you anymore, guys. So again, yes, labor law does protect you. It means that if you made a little mistake, for example, you've been late a couple of times for your work, it doesn't mean that employer has a right to fire you right away. He's not gonna take your job from you right away. He's gonna give you a notice. Yes, everything has to be written down in employment contract. How many notices you can have before getting fired? For example, you can get notice number 1, number 2, number 3, and after 3 notices, if you're not getting better, if you're still doing things that are contraindicated, that you cannot do by the employment contract, after that your employer can fire you. But before that, only because he wants to, he cannot just kick you out of your job. So it means again that employment contract and labor law does protect your rights. Okay, so the contents of the employment contract. The content of the employment contract should be understood as the totality of its terms, defining the rights and obligations of the parties, as well as information about the parties to the agreement. According to the Labor Code of the Kyrgyz Republic, the following information is specified in the employment contract: last name, first name, patronymic of the employee and the name of the employer, last name, first name, middle name. Information on documents certifying the identity of the employee and employer, physical persons, identification number of the taxpayer, information on the employer's representative who signed the employment contract, place and date of conclusion of the employment contract. All conditions of the employment contract are divided into 2 groups: the conditions under which the parties must reach an agreement, mandatory or necessary conditions, and conditions that are established in the employment contract on the initiative of either the employee or employer, additional or elective conditions. So what it means, guys? Also, there is one thing, yes, about this type of contracts. It can be concluded between people, like physical people, yes, meaning employer is a person, one person, and employee is a person. Well, employee is always one person, but whenever we're talking about employer, which is not one person, but it is legal entity, yes, meaning some type of a company, like LLC, legal liability company, yes, or this is individual entrepreneur or something which is known by the law, yes, they are certified, they have documents, yes, this is certified company. Then we're talking about different type of contract. So what this contract has to conclude inside of it? Employment contract has to have all of the information about the employee and employer, yes? We're talking about last name, first name, age. There have to be identity documentation, yes, meaning passport or something like this. It has to have information about the addresses of living, about the phone number, and also all required documentations, guys. Whenever employment contract is fulfilled, whenever it is filled, there has to be a date when it was filled, because since this day you have started working for this person. It means that from this day you have to start making your work, you have to follow your duties, and since this day your worker has to pay you a salary. Okay, so let's move on. The following conditions are obligatory for inclusion in the employment contract: place of work, labor function, work by position in accordance with the staffing table, profession, specialty, with indication of the qualification, specific type of work entrusted to the employee, the date of commencement of work, and in the case when a fixed term employment contract is concluded, also the period. terms of payment, including the amount of the wage rate or salary, surcharges, allowances, and incentive payments, and mode of working times and time rest. Other conditions in cases stipulated by labor legislation. So, again, any law or any normative document or any contract is there to protect you. And we're talking about both parts, yes, about about two parties of this contract. So employment contract will protect not only employee, yes, we're talking about employee because you, after finishing the institute, you're gonna go and find yourself a job and you're gonna be employee, but also it is there to protect the rights of the employer also. So obligatory, meaning mandatory terms which have to be concluded in the contract is place of work. Well, this is obviously because you need to know where you're gonna work, because for example, the place of work isn't written down in the employment contract. What happens is that there are different types of situations which can happen in this life. For example, you started working in a hospital A, yes? And the place of work is not written down in the employment contract. For example, if this employer is gonna build another hospital, maybe in another city or outside the city, and he will tell you that now you're gonna be transferred to the new hospital and you will have to work there, you can't regret. You can't say that you're not gonna go there, yes? Why? Because place of work, it is not written in contract. That's why it has to be inside of it. You have to know where you're gonna work. Also, labor functions, meaning your duties, what you have to do, which position you're going in for. This is also really important. For example, you want to be the head of the department in some hospital, yes, but it is not written in the employment contract, then your employer can just tell you that, no, you're not going to be head of department, you're just going to be regular doctor, yes. Again, bad situation, yes. Another thing which is obligatory is that you have to do the job that you're specialized in, and it has to be written in employment contract also. Easy example. Let's imagine that you are surgeon. Yes, you're a surgeon, you're qualified and specialized to become a surgeon. But it is not written. The position that you're going in for, it is not written in the contract. What if your employer will tell you that you're not going to be a surgeon, you're going to be just simple physician, you're just going to be a therapist, yes, and you're going to go and observe just sick people instead of making surgical interventions. Again, yes, you don't want to be in this kind of situation. That's why position, which is corresponding to your specialty, to your diploma, to your certification, has to be written down in the employment contract. The date, again, yes, whenever you're signing the employment contract, there is a date on the bottom and your signature, meaning that from this day you're going to start working. Or for example, you filled out employment contract by this date, but maybe you're working in another place and you have to finish your duties in another place, then inside of the employment contract you have to write down that I'm gonna start working, yes, in this working place from the date, and you're gonna write down the date. And also, if you're talking about timed manner of the employment contract, meaning that it is concluded for some period, this period also has to be in the employment contract. For example, you're ready to work in this company only for 1 year, then you have to write down this period. That 12 months is the period when you're gonna work for this company. So let's move on. Types of employment contract. Different authors identify different grounds for classifying labor contracts. Some believe that labor contracts are divided into types by the terms: contracts for permanent employment and fixed term contracts. Labor contracts may be concluded for a certain period of not more than 5 years. Others offer a more complex system of differentiating labor contracts, classifying them for the following reasons: the specificity of the subject composition, the identity of the employee or employer, content, effect of the contract. So types of employment contracts, yes, there are many types of them. They can be regular, they can be special, they can be really different, and they differ from every single situation, yes, because it is all individual. But all of these types are under labor law no matter what, meaning that any employment contract has to follow the rules of the labor law. It doesn't matter if you're gonna go for regular job, yes? For example, regular job, I'm meaning that in your case is that you are gonna be hired as a doctor to any governmental hospital or any private clinic. Yes, you're working as a doctor, you're working full-time, yes, like 5 or 6 days a week from morning till evening, yes, regular employment contract. But there are different types of situations. For example, you're working not in one hospital, but maybe 2 or even 3 hospitals. There has to be a special contract for every place because you have your own wishes, like you have your own timetable. For example, you're working in a governmental hospital every day from 8 till 12, yes? After 12, you are free and you want to find another job, maybe in private clinic. So employment contract for governmental hospital and for private clinic has to have obligatory the conditions of each type of job, meaning that if you're working for governmental hospital, the timetable has to be written there, that you're only working there half a day, yes, you're not working full time. Whenever you go and find another job in private clinic, also the working time has to be written down in the labor contract, in a contract, because if it is not going to be written, then your employer can tell you, I'm sorry, but now I want you to work a full time because we have a lot of patients and etc. Yes, but for you it is impossible because you have another job. That's why all of these things necessary, yes, they are obligatory for the contract. Okay, let's move on. The procedure for concluding an employment contract. The procedure can be conditionally divided into several stages. Within the framework of the first stage, the parties carry out preliminary negotiations on the terms of the employment contract, carry out certain additional actions in cases specifically stipulated in the legislation, and also present the documents necessary for the conclusions of the contract. The second stage is characterized by the formulation of the agreement reached. The third stage, the test at employment, is optional, since the conditions of the preliminary test refers to the number of additional conditions of the employment contract. So what it means is that employment itself, yes, whenever you're going to find a new job, whenever you want to work there, an employer wants to hire you, there are several stages that you need to go through. So number one, first stage is obviously after the interview, yes, after you've sent your CV or your resume to the worker and they hired you. Number one is that you have to provide your documentation, yes, as employee. Employer has to provide its documentation, show you if it is LLC, for example, legal liability company, they have to show you documentation, which is telling you that they're working legally. After you have come to some conclusion, yes, there is a decision from the worker and from the employee side that, yes, we're going to work together now. The second stage is there is the formulation of the employment contract, meaning everything has to be now written down in the employment contract. And there is a third stage, but third stage is optional. It is called employment test, yes, meaning that whenever you're going to start a work, sometimes there are works which give you probation time, like testing time. It can be 1 month, 2 months, 3 months, 6 months. So this is a time when employer is checking you. It is checking your qualification, your knowledge, your specialization. It is checking your working manner, if you fulfill your duties, if you work properly, if you can live, yes, if you can communicate well with with your colleagues, with your co-workers. So that's why sometimes some workers give a test time. During this test time, conditions of the employment contract can be different. That's why you have to discuss all of this before starting working. For example, some companies, they provide test time, for example, 3 months, and they tell you that for these 3 months, we're going to check you, we're going to look after you, we're going to see how you perform your work, and for these 3 months, we're going to pay you salary which is less than normal salary which you will get after you go through our testing. So you have to be aware of that, yes, and you have to listen carefully about what your worker is telling you, what he's going to provide to you, what are the terms and conditions of the job that you're going to go for, guys. The first stage, so in preliminary negotiations on the conclusion of an employment contract, a person entering the workforce must provide the employer with the necessary documents that can be divided into 2 groups. The first group includes documents submitted by each person who wishes to enter a job. This is a passport or identity document, a workbook, insurance certificate of state pensions insurance, documents of military registration for persons liable for military service and persons subject to conscription for military service, a document on education, qualifications, or special knowledge. It is prohibited to require documents from the person entering the work in addition to those stipulated by the Labor Code. The second stage, registration for work, is regulated by the Labor Code of the Kyrgyz Republic. An employment contract is made in 2 copies, each of which is signed by the parties. 1 copy of the employment contract is transferred to the employee, the other is kept by the employer. So what it means is that in the first stage of concluding employment contract, each party of these relations, meaning each side, employer and employee, they have to provide documents. So what are the documents that employee has to provide, yes, whenever getting into a new job? Obviously, this is passport or any other identity document, yes, so they can be sure that this is you, not another person. Also a workbook, yes, the workbook where it is written, where have you previously worked, and also insurance certificate, again, because you're going to be paying taxes, and part of this taxes is going to go for your medical insurance, part of this taxes is going to go for your retirement payments. Again, it is all done to protect you guys. And documents of military registration, for example, if you are liable, yes, if you're liable for military service, if you've been to army, yes, and documents on education, again, documents which tell to your, which explain what is your specialization and what type of work duties you can perform, yes, on which position you can be hired at this particular working place. It is so for employers, it is prohibited to ask for any other documents than this, yes, so this is enough. If they are asking for other documents, then you can say that I'm sorry, but it is not under the labor law. This is enough for me to start working at your company. So the second stage is registration, yes, meaning this, signing this employment contract, which has to be under the labor code, yes. It has to follow the rules, it has to follow the law. And employment contract is always done in 2 copies, like any other contract, which is really smart because 1 copy will be in your hands, another copy is going to be in employer's hand. Why it is done? Again, if there are going to be some argues, yes, there are going to be some argues, discussions about conditions and terms of the job. Like, for example, whenever you were getting into this job, your worker told you that you're going to get a salary, for example, yes, like $1,000 every month, not later than 5th of each month, yes? So from 1st to 5th of every month you will be getting paid. But what happens, yes? There are different types of situations. For example, your worker is not paying you. Yes, he's prolonging the salary time, he's not giving you your money, then you can easily bring your employment contract to the job and show it to your employee where it is written that this is your obligations. You promised me, and it is written in employment contract that you're going to pay me this much amount at this period of time. You're not fulfilling your obligations. You have to follow the rules. That's it, guys. That's why, again, all of these contracts and law, they are there to protect us. Restructuring of the employment contract. So the general grounds for termination of the employment contract are provided by the Labor Code of the Kyrgyz Republic. Depending on the form and the will for which the employment contract ceases on the initiative of the employee and the initiative of the employer by circumstances not dependent on the will of the parties. So, termination of the employment contract at the initiative of the employee, dismissal on his own. The employee has the right to terminate the employment contract by notifying the employer in writing no later than 2 weeks. The course of this period begins on the next day after the employer receives the employee's application for dismissal. If the employer has not given consent for the termination of the employment contract before the expiry of the term, the employee is obliged to work out the set deadline. Early termination of work in the case violates labor discipline. However, by agreement between the employee and the employer, the employment contract can be terminated before the expiration of the warning period for the unemployment. So what it means is that we've already discussed the terms and conditions of concluding the employment contract. Yes, how it should be concluded, how it should be filled out, what should be provided for making employment contract possible. But sometimes you need to leave this job. Yes, sometimes your worker will fire you. Well, I hope it's not going to happen to you, but it is life. Yes, anything can happen. So employment contract can be stopped. Yes, can be annullated in three ways. So number one is by the will of the employee. For example, employee doesn't want to work there anymore. It is employer's will. Number two, by the will of the employer. And number three are all of the situations which are not related or they do not depend on employee and employer. So number one situation is when employee wants to stop the contract. He wants to stop working there. What he has to do is that he has to write down application asking for the employer to stop the employment contract. This application has to be given to the employer not later than 2 weeks prior to the date when he wants to stop working. For example, yes, today is 20th of January, and if the person wants to stop working in February, yes, he has to give this application 2 weeks prior to the deadline. And so why 2 weeks? 2 weeks are given for the employer to find another person who will switch this person's place, yes, because this work has to be done and the employer needs to find another person who's gonna work in this place. Also, so there are some situations which are urgent, emergency situations. For example, employee is gonna stop working because of health. Yes, maybe his health condition is not letting him to do this job anymore, and even the next day maybe it is not possible for him to come to the job. Then it is not always necessary for him to continue his work until the deadline. Everything has to be discussed individually between employee and employer. But if employee is able to continue his job until the deadline before employer finds another person and they teach him how to work and etc., then it's okay. Everything has to be under the labor law, yes? The rules have to be followed. So another situation is then termination of the employment contract on the initiative of employer. termination of the employment contract at the initiative of the employer or its representatives is established in the Labor Code of the Kyrgyz Republic. Some of them are connected with the guilt of the employee, others with the circumstances of a production and economic nature, and others with the personal qualities of the employee. So the grounds for the termination of employment contract on the initiative of employer are liquidation of an organization or termination of activity by an individual entrepreneur, reduction in the number of staff of employees of the organization, individual entrepreneur, discrepancy between the employee of the position held or the work performed due to insufficient qualification confirmed by the results of attestation, change of the owner of the organization's property, repeated failure by an employee without valid reason to perform employment duties if he has a disciplinary penalty. So another situation is when employer wants to stop employment contract. When this can happen? Simply when employer is not doing his job properly, employee is not doing his job properly, or there are some situations which are not related to employee, they are related to employer. What are the situations? Number one is that simply the place where the employee was working is shutting down. Yes, like production is closing down, the company is shutting down, then what can happen? Simply all of the employees are going to be fired, yes, because there is no working place anymore. When the owner is changing, for example, there was one private clinic, it has one owner, but due to some circumstances, he sold his business, he sold his private clinic to another person, and maybe this person, he has his own vision of future of this private clinic, and he will fire all of the doctors and hire another people, or maybe he will totally switch the type of his company, yes. Another situation is when employee, the worker, he is not fulfilling his job totally, meaning that he is breaking the rules all the time. He is late, he's not doing his job good, which was written in the employment contract. Another situation is when employee couldn't pass the attestation, yeah? So there are tests. For example, they hired the person and he has test period of 3 months. After 3 months, this employment contract can be annullated by the employer because he thinks that this person doesn't have enough qualification, enough knowledge, enough specialization to do this job. Okay. Another reason, guys, a single gross violation of the employer's job duties. Absenteeism, meaning absence in the workplace without good reason throughout the workplace. Appearance of an employee at work in a state of alcohol, narcotic, or other toxic intoxication. Disclosure of legally protected secrets, including the disclosure of personal data of another employee. Committing at a place of work theft of others' property, embezzlement, intentional destruction or damage. Violation of the labor protection requirements if this violation entailed grave consequences. Accident at work, accident or disaster. Making unreasonable decision by the head of the organization, his deputies and the chief accountant entailing a violation of the security of property, improper use or damage to the property of the organization. A single gross violation by the head of organization, submission of false documents by the employer to the employer upon concluding an employment contract. So another reason, again, yes, when employee, he's done some violation, meaning he broke some rules. It can be absenteeism when simply employee didn't come to work without even telling to his worker what happens. When a person comes to the job when he's drunk or when he's high under some narcotics or other toxins, yes. When employee is doing something unlawful while being at working place. For example, he stole another employee's property. Yes, he stole his money, his phone, or anything. Also, another situation is when employee, while being at work, he's doing some damage. He's doing damage or unlawful things to the property of the employer or to other employees, to other people. Yes, at these cases, also employment contract can be annullated. It can be stopped by the employer. Another situation is when employee, when getting hired to this job, he provided the employer with the false documents, meaning the documents which are not correct. Yes. This also can finish the employment contract from the employer's side. So the termination of the employment contract for circumstances beyond the control of the parties. In accordance with the Labor Code of Kyrgyz Republic, the employment contract is subject to termination for the following reasons, not depending on the will of the parties. Calling an employee for military service or referring to an alternative civil service. Restoration of the work on employment for previously performed this work upon the decision of the State Inspection of Labor or Court. The employer who is to be dismissed must be offered the employer another proposed job as a vacant position or work corresponding to the qualification of the employee in a vacant lower level position or lower paid job. Non-election to the position. This reason for termination of the employment contract applies to those employees with whom the employment contract was concluded in connection with the election of them for a certain period of time, including the results of the competition, condemnation of the employee to a punishment that excludes the continuation of the previous work. In accordance with the verdict of the court which entered into legal force, the employee is convicted of a sentence excluding the possibility of continuing this work, arrest, imprisonment, and etc. Recognition of an employee is incapable of working in accordance with the medical conclusion. Death of an employee or employer and individual, as well as recognition by a court of an employee of an individual employer and individual who is deceased or missing. The emergence of emergency circumstances hindering the continuation of labor relations, military actions, a catastrophe, a major accident, and etc. Expiration, suspension for more than 2 months, or deprivation of the employee of a special right. License, driving license, other special rights. If this entails the impossibility of the employee performing duties under the employment contract. So number 3, yes, number 3 condition where an employment contract can be stopped or annullated are the situations which do not rely on employee or employer. Those are catastrophes, some accidents like corona crisis going on. Yes, so corona crisis, some productions have shut down. It doesn't depend on employer and employee, so employment contract is going to be annullated. Also situations when employer or employer died. Yes, again, it doesn't depend on anyone. If the person is missing, yes, if he's missing, also the employment contract is going to be annullated. So non-election to the position. For example, this person was the head of the department. There is a concurrency, meaning that there are another doctors who want to become head of department also. And if this person is not, if this person cannot do the job of the head of department anymore, then another person is going to take his place. Yes, again, this is non-election for the position. So disciplinary punishment can be applied only for violations of labor discipline in the work process. In the event of damage to the interests of the employer outside the established duration of working time or not in the performance of duties under an employment contract, the employee cannot be brought to disciplinary liability. The composition of a disciplinary offense includes 4 elements: subject, subjective side, object, and objective side. So the subject of disciplinary offense is a citizen who is a specific employer in labor relations. Subjective side is attitude of the employee to his misconduct. Responsibility occurs if his guilt is expressed in the form of intent or negligence. The object of disciplinary offense is that which the intruder encroaches upon. Object include the rights and obligations of the parties to the employment relationship, the interest of the organization, the state, the employer's property, the rules of internal labor regulations, and so on. The objective side of disciplinary offense is a form, actions or inactions. On the objective side, a causal relationships must be established between misconduct and harmful consequences. So what happens is that when there are situations when an employee is breaking some rules, yes, we have to distinguish between Did this employee break the rules which are under the labor code? Meaning he broke the rules which are directly related to his job. Or did he break the rules which are not related to his job while he's not at working place? Yes, those are totally different things, guys. They have to be distinguished by each other, between each other. So the current labor legislation provides for two types of disciplinary responsibility for workers: general and special. General disciplinary responsibility is provided for by the internal labor regulations on the basis of labor code and applies to all employees except those for which special disciplinary responsibility is provided. Disciplinary sanctions are a measure prescribed by regulatory acts. Employers do not have the right to change the types of disciplinary sanctions at their discretion. At present, the following penalties are established by Labor Code of Kyrgyz Republic: remark, reprimand, dismissal on relevant grounds. At the same time, dismissal from work as a measure of recovery is allowed only in cases directly provided by the law. The list of disciplinary penalties fixed in Labor Code is exhaustive. This means that the application of any other penalty is illegal. It will be illegal, for example, to transfer an employee to lower paid work in the order of a disciplinary penalty or the collection of a fine. The use of penalties is not the duty, but the right of the employer. So special disciplinary responsibility is borne by the workers who are subject to special charters and discipline regulations. From the general disciplinary responsibility is different. A circle of persons subject to the relevant rules. Disciplinary punishment, they are as a rule more stringent. On a circle of persons and bodies appointed by disciplinary authority. According to the Labor Code of Kyrgyz Republic, before disciplinary action is taken from the employee, a written explanation must be requested. If after the expiration of the 2 working days the said explanation is not provided by the employee, an appropriate act is drawn up. However, the failure to provide an explanation by the employer cannot be an obstacle to the application of disciplinary punishment. Disciplinary punishment is applied directly after the discovery of a misdemeanor, but not later than 1 month of the day of its detection, not counting the time of illness of the employee or his stay on leave, as well as the time needed to take into account the opinion of the representative body of workers. The day of detection of misdemeanor is the day when the person who is at work, subordinate employee, became known about the commission of an offense, regardless of whether it is endowed with the right to impose disciplinary sanctions. Disciplinary punishment cannot be applied later than 6 months from the date of the commission of the offense, but on the basis of audit of financial and economic activity, or auditing 2 years after the date of the commission. At the same time, the production time for the criminal case is not included in the specified time limits. Meaning, what can happen? So there are different types of situations when person is working in any job, yes? Let's imagine that he did some misdemeanor or he did some offense or crime, yes? If it is related to the work, directly to the work that he's been doing, then it is going to go under the labor law. So the date when this misdemeanor or offense was detected, yes, is the date from which everything starts. Not later than 2 days are given to the employer, so he can, when he should, yes, come to the employer and explain what happened and why it happened in a written form. If this explanation was not provided, then disciplinary punishments are starting. It has to be done not later than 1 month since this misdemeanor or offense was detected. But as it was said in the previous slide, all of the disciplinary punishments are written down in the labor code, meaning that employer cannot just choose the type of the punishment for the employee on his own, because everything is written down in the labor code and he has to follow the rules, guys. Applying a measure of disciplinary punishment, the employer is obliged to issue an order which is declared to the employee against a signature within 3 working days from the date of its publication, not counting the time of absence of the employee at work. At the same time, the worker's refusal to certify by his signature the fact of declaring an appropriate order to him on the validity of the declared penalty is not affected. In the event of an employer's refusal to sign the said order, an act is written. Disciplinary punishment may be appealed by the employee to the Federal Labor Inspectorate or bodies For the review of labor dispute, the body considering the labor dispute can cancel the imposed penalty, however, it cannot be replaced by another. Disciplinary punishment can be withdrawn by the employer after a year at the request of the self-employed person, at the request of his immediate supervisor or representative body workers. At the same time, the Labor Code doesn't set any minimum deadline after which the issue of removing the disciplinary penalty may be raised. Material liability. The party to the employment contract, employer or employee who caused harm to other party is obliged to reimburse it in the amount and in the order established by the Labor Code. This duty of compensation is called material liability for labor law. Depending on the subject who caused the damage, distinguish the material responsibility of the employee to the employer and responsibility of the employer to the employee. The liability of the employee is duty to compensate completely or, in the part, the damage caused by his unlawful guilty act to the property of employer, in the manner and within the limits established by law. The basis for the employee's involvement in material liability is labor offense, resulting in a damage to the property of the employer. Based on the legislation, we can distinguish four conditions of material responsibility of workers: presence of direct actual damage, causing damage to the employer by unlawful conduct of the employee, presence of the employer's guilt in causing damage, the existence of causal link between the harm that has occurred and the guilty wrongful behavior of the employee. Depending on the nature of the unlawful actions, the form, the type of property, and certain other circumstances stipulated by law, the employee may be brought to full or limited liability. Limited liability is due to the fact that compensation for damage is limited in relation to the wages of the employee, and full because the employee reimburses the damage without any restriction. Full liability, liability in the amount of damage caused, is assigned to the employee only in cases provided by law. 4. Damage caused to the employer when the employee performs work duties. The shortage of value is entrusted to the employee on the basis of special written contract or received by him and one of document. Deliberate infliction of damage by employee. Causing damage in state of alcohol, narcotic, or toxic intoxication. Causing damage as a result of the employee's criminal actions established by court's verdict. Causing damage as a result of administrative misconduct. Disclosure of information constituting a secret protected by law. Causing damage not when the employee performs work duties. What are liabilities of the employer? The Labor Code provides for the following types of material liability of the employer or its representatives to employee. For damage caused as a result of non-receipt of wages in all cases of unlawful deprivation of the opportunity to work. For damage caused to the property of the employee. For delaying wages and other payments due to the employee. Okay, guys, so thank you for your attention. We're done for lecture number 1. See you at next lecture.